Good afternoon. I would like to welcome everyone to the webinar on the concept of corporate criminal liability. My name is Celina Nowak, and I'm a chair of this webinar. We have several panelists, and we will be discussing for about 75 minutes. That's the time that we have for the webinar. The webinar is part of the European Law Institute Annual Conference, and it will focus on the prospective ELI project on the concept of corporate criminal liability. ELI came up with the idea to address corporate liability, corporate criminal liability last year. And then they invited myself and Dr. Fabio Nicolipia to co-lead a project on this issue. We have prepared a feasibility study for this prospective project. And this study has been shared with the panelists of the webinar today. And we would like to discuss the project, the prospective project, the idea, and well, some general issues related to the corporate criminal liability within the European Union. The chat has been yes, we have one more panelist joining us now. Thank you. The chat for the webinar has been closed, but there is a Q&A session planned for the end of the seminar. So if anyone from the attendees would like to ask a question, please use the Q&A icon on the bottom of your screen, and please write your questions as soon as possible so that we can then address your questions at the end of the webinar. And now, without any further ado, I would like to talk a little bit about the project and the idea that we had. The title that was given to us by ELI was the concept of corporate criminal liability. And myself and Fabio, we thought that it was a very interesting issue, because obviously the liability of corporations is an important issue for criminal law, both on the national and on the European level. Corporations do contribute to crime and do profit from crime. And so it only seems fair to hold them liable for crimes that were committed by individuals linked to those corporations. And then we, when I'm saying individuals linked to the corporations, I'm already starting to address some details that we will have to tackle within the project. A corporation as such is a legal fiction and cannot commit a crime. So there must be an individual, a human being, that actually perpetrates the crime to the benefit of the corporation. And there is a variety of issues related to the relationship between the individual and the corporation, the need to identify the individual, or maybe the need not to identify the individual. As you may be aware, in the different member states of the EU, we have different legal frameworks related to liability of corporations for crime. In some member states, this liability is recognized as criminal. In other member states, the liability is recognized as quasi-criminal, and in some states it's just administrative liability. But we think that there is a need for a more coherent approach when it comes to liability of corporations for crimes in the EU, because we think that there's a need for a better response to corporate crime in the member states, and for a safer environment for the citizens. We also appreciate the necessity to tackle corporate crime when it comes to the protection of the financial interests of the Union. This is also an important issue. When we were doing the feasibility study, we realized that actually the title that was given to us by the European Law Institute was too narrow. And during a meeting with the council of the institute last week, we decided to widen our, it was decided by the council to widen our mandate and to just go beyond just the concept of corporate criminal liability. And we would like the project to address other issues as well. First, the attribution of liability, then sanctions, and some procedural issues. We think that the label is not as important as it seems, and so the concept of liability is not something that has importance in itself. What we would like to achieve is a comprehensive approach and effective sanctioning policy throughout the Union, and whether it is criminal responsibility or administrative responsibility, this is not maybe such an important point when it comes to corporations. The project, the idea of the project is based on a comparative legal research, quite classical, with 7 member states chosen for the study. We wanted to cover a variety of legal systems that have different legal solutions adopted with regard to corporate crime. We would like to cover Italy, Poland, Germany, the Netherlands, Lithuania, and the Czech Republic. And then, based on the findings established in those national reports, we would like the project team to elaborate a set of model rules that could be adopted then by legislators on the national level, and maybe eventually by the Union on the European level. So that's the general idea, that's the general framework of the project. And now I would like to ask Dr. Fabio Nicolica to address the project and some other more detailed issues than related to the project. Fabio, please.
Thank you for the floor, Selina, and good afternoon, everybody. Before beginning my short presentation, please just let me thank the ELI for the invitation to the conference and for the opportunity to share my views with distinguished scholars and experts, and also thank again to Selina who invited me to join the staff of the project on corporate criminal liability. So as you already heard from Selina's presentation, of course, the main subject of our prospective project project lies in the issue of the nature and the attribution of liability to legal person, to corporation. But we noticed that during our discussions, as Selina was saying before, that the object of our project actually goes behind this issue of the nature and attribution of liability to legal person. And there are also other very important problems that our study aims at tackling, other aspects such as, among others, the one of sanctioning, the sanctioning policies of corporation that Selina already mentioned. There is a very relevant and complex issue if only we consider that from the sanctions that are imposed to the corporation finally depends the effectiveness of the prosecution against the entity, and so the effectiveness of the deterrence of the liability. So obviously I do not have enough time to deal properly with the topic today because we have only a few minutes in our presentation, but there is at least one aspect that I would like to share with you, and is the fact that we all know that when it comes to corporate criminal liability, many legal orders make great use of leniency policy, especially for the cooperating corporation. Now, sometimes when the corporation cooperates with the investigators, the prosecution is even simply declined, and so no sanction is imposed at all to the corporation. We have a bright example of this tendency, for example, in the phenomenon of the DPA and NPA in the North American legal system, but also in Europe we have some related practices where the legal orders accept to decline the prosecution against the entity if it shows compliance and cooperation to the investigation. Well, I'm not at all prejudicially contrary to this kind of approach, but I think we should reflect very carefully if establishing a criminal or a quasi-criminal liability of corporation assisted by the widespread use of these mechanisms is really the best way to ensure deterrence, even thinking to the position of the individual who is the material author of illicit acts which are linked to the liability of the corporation. I mean, there are some interesting studies, for example, which show how the corporate self-reporting may effectively enhance deterrence, but only if the level of the corporate leniency is within a certain range. But if the level of the corporate sanction decreases excessively, then the probability of crime occurring increases without consequences for the individual. In other words, and putting it more simple, if corporate sanctions are reduced excessively, then this will reduce deterrence also in respect of the individual wrongdoers. So the issue of the cooperation also recalls some problems, some topics which are of a procedural nature. No, the general question here is if we want the entity to enjoy just the same rights and prerogatives of the individual, or if we think that some distinction might be admissible in this field. For example, a very important and crucial issue is if we think that the corporation should enjoy the nemo tenetur sed tegere principle just as the individual does. But there are also more specific problems when it comes to criminal procedure, to corporate criminal procedure. After all, we should consider that the entity is a legal fiction. So adequate techniques of representation at trial should be envisaged. And this might be not so easy because from one side, we have to be sure that the entity is effectively represented into the trial, into the proceeding against him, it. But on the other side, we should also avoid conflict of interests between the corporation and its human representatives, which are the ones who materially participate to the trial in the names of the entity. So, and again, taking a cue from the debate which has been developed in North American country, there is also, I think, the need for more specific rules for the performing or corporate internal investigation, which are a very common way of investigating illicit acts into the corporation, but where the employee's right might be might be in great danger without adequate legislation and rules who regulate this kind of procedures. So this is, of course, only a very quick insight of some of the most relevant problems in corporate criminal liability. But I think it is enough to show the need of a common approach in the European legal area to this very complex issue in order to effectively combat the crimes of the corporation and also to protect the union financial interests, which usually come at stake when we are speaking about white-collar crimes and corporate liability. But we should, I think, reach this objective always respecting the rights of the corporations and of the individual in accordance with the European standard of safeguards, which is exactly the main ambitious goal that our prospective project aims to fulfill. So I hope you heard me throughout my presentation. Of course, I'm at disposal for any questions, and thank you very much for your attention.
Thank you, Fabio. Thank you very much for this short presentation. As you can see, Fabio and I just complement each other because I am more into material criminal law, whereas Fabio is more into procedural issues, but that was the idea for the project. And now hoping to get some questions in the Q&A for this webinar. Now I would like to ask to take the floor. I would like to ask Dr. Peter Tsonka, head of the General Criminal Law Unit in DG Justice, to take the floor. Dr. Tsonka has a presentation for us. Yes, we see that now. Thank you.
Thank you very much, Selina, and good afternoon to everyone. It's good to be with you. It's a very useful and important topic. Perhaps it is something where we can improve union law. And this is what I would like to talk about briefly in reaction to the idea, the project that you just presented, which is to develop model rules that could inspire national legislation and EU instruments as well. The liability of legal persons is well known in EU law for many years, and it is included in EU criminal law instruments as well for more than 25 years. But it's not as simple as it sounds. It never is. So we go to the next slide. And in fact, the complication comes from the treaty itself. The treaty requires the union legislator, that is the council and the parliament, to respect the legal systems and the traditions of our member states. Article 67, which means that in the specific area of criminal law, member states may object to a harmonization which would go beyond what is necessary to achieve in a area of freedom, security, and justice, and which would not respect principles such as proportionality and subsidiarity, which are the leading principles of EU law. As a result, so far, we have not managed to introduce only corporate criminal liability, emphasis added on criminal. We have various systems of corporate liability in our member states, but they vary, and some still, as of today, do not recognize the criminal liability of legal persons. Although we all know that societas delinquere potest, they may not be held liable criminally in all our member states. And that is largely because of the differences in traditions between our member states. Some, such as the common law systems or the Nordic countries, more easily recognize the liability in criminal law of legal persons, which is, of course, a fiction, whereas others focus on the liability of the physical natural person. The first time we have identified the different options of holding corporations liable was in the second protocol to the PIF Convention in 1998, so that's more than 20 years ago. And ever since, we kept repeating essentially the options that we offer to our member states with the same substance. And in terms of substance, what we mean is that we allow our member states to introduce either a system of liability based on criminal law for corporations or any other system which will ensure that these sanctions are effective, dissuasive, and proportionate on the legal person, but without requiring that they be subject to criminal sanctions. And we have some member states which systematically choose a non-criminal, essentially administrative way of punishing, sanctioning legal persons. One of the common elements that we have in the system developed by the Union is that the requirement to hold legal persons liable is for certain types of people in the corporation, which we call vicarious or derivative liability, because they commit offenses for the benefit of the corporation. And it's either because they are in a leading position, so they represent the corporation, they take decisions, or they have controlling powers, for example, in the board. And therefore, they engage the responsibility of the corporation because they act on behalf of the corporation. And the second type of engagement of the legal person's liability is the ordinary person who works within the corporation under the supervision of a supervisor who misses the opportunity to supervise. So it's a lack of supervision, which is the factor triggering the liability of the legal person. And the second key principle is that, of course, corporate liability is one thing. It never excludes holding the physical person liable at the same time. So there is no problem of nebis in idem. The corporation and the legal person can, and the physical person can be both held liable for the same offense. Next slide, please. Thank you very much. So as I said, 1998 was the adoption of the second protocol to the PIF Convention, which essentially related to the liability of legal persons in connection with offenses defined in the 1995 PIF Convention. That is the convention establishing for the first time offenses which harm the European Union's, at the time, the European Community's financial interest. So fraud, money laundering, corruption, active and passive corruption against the Union's finances. Today, this convention and the protocols are replaced by a directive of 2017, which is currently being subject to an implementation report, which we just issued last week. You may wish to look at it because there is a section on the liability of legal persons in that report as well. But all this to say that since 1997, we keep repeating the same principles in EU instruments with some tiny variation in the post-Lisbon directives. And in essence, what we want is that our member states introduce sanction systems which are effective, proportionate, dissuasive. I said so. These must include fines, either criminal or non-criminal fines, and may include, so these are possibilities, a certain number of measures, such as excluding the legal person from public tendering, temporary disqualification, placing under judicial supervision, or even a judicial winding up closure order. And we have been including these measures in the various directives of criminal law since the Lisbon Treaty and also before. And a tiny variation concerning the people who are under supervision. So therefore, those which are not in a leading position is that there are some other additional measures which are listed. And this is the last bullet point. Can we go to the next one, please? Again, the differences are tiny in the penalties that we set out in the pre- and post-Lisbon directives. And I listed here a few examples in the post-Lisbon directives on sexual abuse of children and cybercrime. For example, the idea of temporary or permanent closure of establishment or exclusion from public tender. This is all in the PIF, the money laundering and the non-cash payment directives. Next slide, please. Now, the future. The first thing is that as long as we don't change the treaty, Article 67, we will have this constraint that we must respect the legal traditions and legal systems of our member states. I personally doubt that this will ever change. I think in the area of criminal law, which is very sensitive and has been so ever since the European Union entered this area, it is unlikely that we will get rid of this limitation, which means that introducing a full harmonization requiring member states to introduce only corporate criminal liability is unlikely in the future. It may happen, but I'm not very optimistic. And remember that in Article 83, which is the legal basis for substantive criminal law, and therefore the legal basis for sanctions under union criminal law as well, which means this is the legal basis for sanctions against legal persons as well. This is an applicable principle, so we always have to respect legal traditions and legal systems of our member states. Second point, of course, the evolution of criminality may push us into an evolution of European criminal law as well. The next attempt will be the revision of the Environmental Crime Directive, which the Commission identified as something deficient and which needs revision. And one of the key areas of revision will be sanctions. Because of the special legal basis, pre-Lisbon legal basis in the first pillar that we had taken at the time when this directive was introduced, it is not actually a criminal law-based directive. We could not introduce levels or types of sanctions in that directive. And now, this time, we will do this, and we will go into detail about sanctions for physical and for legal persons. Do we manage to go beyond this traditional obligation that the member states need to introduce some type of a liability for legal persons? I doubt it, but we will see. We will push it as far as we can. Certainly, we will introduce all the additional measures that I have listed, which are missing in this area. And we know that in the area of environmental crime, corporate offending is very frequent. So we must ensure that member states hold legal persons, corporations liable. And just remind you that legal persons have been defined systematically in our directives and framework decisions as excluding public persons and the state itself. So public bodies such as municipal councils cannot be held liable, unfortunately, in my view, under these directives, whereas in some cases, at least in the area of environmental criminal law, it would be necessary. We will also add possibly a new measure to reinstate the environment, which is more a civil or administrative law type measure. We will see whether we will manage to push this through. and we will add things which have been added recently in directives on financial crimes, including on fraud against the union's budget, which is confiscation and recovery of assets. And the last point I wanted to raise is that, of course, now we have the EPPO, which started its operational work on the 1st of June, and the European Public Prosecutor's Office will prosecute not only physical persons, but also legal persons. This may push the union into a degree of evolution if they see a problem of judicial cooperation and the fact that we cannot prosecute the same company in one country in the same way as we would do it in another, which is nonsense. The EPPO has a wide competence to prosecute in 22 member states, hopefully in more in the years to come. And we would like to make sure that it can actually achieve the same results in terms of prosecution and convictions in all the 22 member states. Whereas for now, at least as far as corporate liability is concerned, this is not possible. Thank you.
Thank you very much, Peter, for this very interesting presentation of the difficulties and challenges that face that are before us, that we have to face, and that the member states and the union has to face. I come from the state that does not join, that didn't join the EPPO, so there's another legal and practical challenge, unfortunately, if I may just say so. But hopefully it will change, as you said. Still hoping for some questions to our panelists, to Peter and other colleagues. So I am encouraging attendees to use the Q&A icon on the bottom of your screen. And now I would like to ask, without further ado, I would like to ask Professor Mark Engelhardt to take the floor. Professor Engelhardt is an adjunct professor of criminal law in the Goethe University in Frankfurt am Main, and also a researcher at the Max Planck Institute for the Study of Crime, Security and Law in Freiburg in Germany. Mark, you come from the country that does not recognize criminal liability of corporations. So we are looking forward to what you can tell us about this important issue. Please.
So thank you, Selina. Good afternoon, everybody. It's a great pleasure and honor to be with you this afternoon. And yes, of course, I come from a kind of dinosaur country concerning corporate criminal liability, coming from Germany. Insofar, it seems a bit old-fashioned what we have in Germany, but this old-fashioned system has triggered a discussion, a large discussion for the last 20 years, if we do not or shall not or must not change the system. And there has even been a proposal for a kind of corporate criminal liability legislation that was proposed by the federal government last year. It has been heavily criticized, and now, unfortunately, with the end of the term, of the parliamentary term this month, it will not become a law, at least in this parliamentary period. But nonetheless, we have a kind of very detailed discussion materials. I think every lawyer in Germany has written something on the topic. Insofar, we have many things we have fought through in the recent years. And I just want to take and pick up some of the aspects in my next few minutes. And I just want to say that the project is very valuable from my perspective, because it really includes attribution, sanctions, and procedures. And in my view, you cannot deal one apart from the other, because they all must match together. And this more or less leads me to my first aspect about criminal corporate liability. The term criminal is that what is really the non-word in Germany. If you say it's criminal, then you have a kind of big opposition. From my view, it's not so important if you name it criminal or not, if you just say we have a kind of liability system, because the main emphasis is not the word criminal, but the kind of attribution model you choose. Because one thing is clear, the corporate criminal liability can never be identical with the one for a natural person. So there's always a kind of different set of attribution. You have a kind of reasoning that's behind it. And insofar, I think the main focus should not very much on the criminal aspect, but on how and in how far is a corporate entity liable. And this has been one of the things that has not been discussed so much in Germany, because many have just looked at the PIF convention and said the existing administrative or quasi-criminal system in Germany has implemented the PIF convention, and in my regard, they have it done properly. But I think the PIF convention was in the 90s, and it has not taken up one main development that was also mentioned by Fabio, the compliance development. Because what we see in the compliance development is a very close interlinking of prevention and repression. And especially in the corporate context, we can really link it because some duties you have as a corporation can be taken out or can be implemented by criminal law. And insofar, that's something I will come back on the sanction side. But on the first aspect, we should think about a bit more, when can a corporation be criminal? And then we can say, oh, it's not just the persons acting there, but it's also the corporate structure in there. It's the corporate ethics, everything that makes people maybe more prone to do criminal things, because it's much easier within the corporate context, because they have resources they do not have on their own. So there are many aspects with that. And I think attribution model should pick up something of that a corporation is only then responsible not because one person commits a criminal offense, but because the corporation has not done something to prevent this. And insofar, there's a kind of lack of supervision, like we already have in the PIF convention mentioned. But I think one could elaborate a bit more on that. What must the corporation do in order to prevent the natural persons acting within the corporations in a criminal way? Then, second aspect concerning sanctions. What we have seen in the German discussion is that we have in the existing system a very rudimentary sanction rule. There's just a fine possible. There are no other sanctions really possible. Of course, Germany fulfills the PIF convention criteria by saying that we can close cooperation by administrative measures insofar such measures are possible, but it's not really in the sanctioning regime. Insofar, a judge who orders a kind of administrative sanction, he can only order a fine, but he cannot refer to further measures. And what we have seen a bit in the discussion is that even for determining a fine, there is not really so much criteria, because it's not the same if you have a natural person or if you have a corporation. What we need is criteria to say this is in favor of the corporation or this is against the corporation, in order to determine the fines, especially as the fines are now millions. It's not just the thousands we had in Germany. So if you had a fine up to maybe 1,000 to 5,000 euros, then it was not so decisive if you have clear criteria. But if you're in the field of millions, then you should have, for the judge, for a kind of legal security, a kind of system, at least what could you refer to, what could you put on that side and on the other side in or against the corporation. And then last but not least, I think it would make very much sense to have a kind of compliance sanction or a kind of obligation to reform the corporation. I think if I just mentioned the revision of the economic, of the environmental crime directive. Especially in the environmental field, we see many corporate failures that lead to a pollution of the environment. And so far, it would make sense if you have a kind of judge looking what has been wrong, that he can order something to improve the system, maybe a kind of supervisory system, and maybe they have to use better oil tanks or something like that. That would make clear sense and would have a clear preventive, future-oriented aspect within a kind of sanction system. So far, we tried a bit to include that in the German reform proposal, and there are already a kind of obligations that could be, with the consent of the corporation, be part of a kind of sanction, that the corporation says, yes, we improve certain aspects, and that's part of the sanction. Then last but not least, I will touch procedural issues. Very important in that regard is to look not only at the rights the corporation has, of course, that's very important, but I think there's another aspect we shouldn't leave out, that there is hardly, the majority of cases does not go to trial stage. There is no formal ruling in the end, but proceedings end before, for many reasons. And I think there's no difference between natural persons and corporations. And there are, at least in the German system, almost no rules on kind of formalistic approaches how to end these proceedings, in what cases, and especially not what kind of informal sanctions or what kind of measures could be implied nonetheless. If you strike a deal for saying, okay, you admit your guilt and you say you improve something, then we end the proceedings for many reasons, and especially you have to think of public resources. They are scarce, and especially in the economic context, they are often very complex. So it makes sense not to go through a very big trial to the end, and where you might even lose something. Maybe it's more sensible to end the proceedings before and to have some clear rules on that. And what we really miss in Germany is, for example, that a prosecution service could say, okay, we end it, you maybe pay a certain sum that you agree on for admitting your guilt, or you really improve, like you take some preventive measures, and we end the proceedings. And so far, it would make sense to do that. And at this point, I always just say there we have to be careful, because practice has already shown that going for a deal creates a kind of pressure on the corporation, that in some cases corporations are really forced to cooperate with the kind of threat that otherwise, if you do not cooperate, then you will experience severe consequences. And I think that if we develop a kind of a system, especially for the procedural part, then we should take into account that there is no abuse possible. So insofar, we have to have kind of protection mechanisms for the corporations. In the past, if the prosecution sometimes has said, especially the American prosecutions, we want A, B, and C, then the corporations just said, okay, we do that because we really fear the consequences. And I think that's not procedural justice. There has to be a fair attribution between the prosecution and the corporation. And so far, I want to conclude what we see from the German system is that we really need all steps developed, attribution, sanction, and procedure, and that especially the inclusion of preventive aspects is one of the key discussion points we have seen. And I think if we want to improve something in the field, then to include that in the future would be valuable, especially if we had for Germany a kind of European framework. This might even convince some in Germany to introduce a criminal liability system. So far, thank you very much.
Thank you very much, Mark. So we are looking forward to hearing some more news from Germany and learning about German flexibility. We'll see how it goes. Now, last but not least, I would like to ask Professor Willem Helvoet from the University of Groningen to take the floor and tell us something about the very pragmatic Dutch perspective on the corporate criminal liability. Pim, the floor is yours. Thank you.
Yes, thank you very much, Selina, and thanks for the kind introduction and for having me here. It's truly an exciting topic. Can you hear me, by the way? Because I had some technical issues. Okay.
We can hear you, but it seems that you are far away from the mic. So maybe you
I'll try to speak up a bit. Yes?
Okay, lovely. Thank you.
Thanks a lot. I really agree with the previous remarks that it is very important to have a holistic attitude to take both into account substantive law, procedural law, and sanctions. But I'm very much looking forward to possibilities for getting to model rules and to some standards to point to, particularly with the prospect of harmonization. I really don't hope that we will find the lowest common denominator. I would really like to have a more ambitious approach, but it could be difficult because, as already was mentioned, there are some countries that are very reluctant to have corporate criminal liability, whereas the country where I'm from is perhaps the other extreme. I'll try to sound not too parochial, but I might do now and then because I refer to my own legal system. It is pragmatic, that's true. We never had a very good doctrinal discussion on whether or not legal persons should be held criminally liable. Before that was introduced, the legislator just said we're going forward and let the courts sort it out. And now we're stuck with that. But our courts have tried to find a good way. I think an abstract question is, of course, do you want that or not? And as you've said, legal persons are a fiction. That might be true, but I think that natural persons are a fiction too. Being a natural person is a kind of a construct that enables us to assign blame towards a particular human being. But the fact of a legal person, the construct of a legal person, of a natural person is also a construct, I would say, and therefore not different from the concept of a legal person. And of course, there's a classic saying, legal persons don't have a soul to damn or a body to kick, and therefore we shouldn't have them in the criminal law. But nowadays, luckily, we don't damn souls and we don't kick bodies of natural persons. So there's, I mean, that's not a relevant viewpoint anymore. But I do think an important question is what offenses could legal persons commit? All offenses, particularly regulatory offenses. It was thought in the past that legal persons could not commit all offenses, that there would be certain offenses such as rape or homicide that legal persons could not commit. Nowadays, we don't think that anymore. For instance, in a brothel, or if you have a group that works in a particular sector, that could very well be the case that there is an organization behind that commits a rape. But then the question is how to attribute certain acts, certain circumstances to a legal person. We have a bit of a difficult thing there. Normally we have a tripartite system, but there is a kind of a preliminary question: who is the perpetrator? The perpetratorship is a kind of a preliminary question in our system, and that is particularly relevant when it comes to legal persons. And there the Supreme Court has taken a very broad approach. They've said if an act happens within the sphere of a legal person, then it is the legal person that committed the act. But then leaving aside all the other elements of the offense, just review the legal person as having committed the act. And then there are a couple of circumstances that can contribute to the question whether or not the act was committed within the sphere of the legal person. Circumstances such as, did an employee commit the act? Was the act useful for the legal person? Did the act fit within the legal person's normal business operations? And lastly, could the legal person control whether or not the act took place? And did it agree or accept that such an act took place? Or did it omit to take precautionary measures? So those are 4 circumstances that are used to decide whether or not a particular act was committed within the sphere of the legal person. Then it can be attributed. But it's definitely not really settled that this will remain so forever. There also always have been some alternatives on the table, particularly in doctrine, that, for instance, don't agree with the idea that you could have some subjective elements deciding whether or not a legal person would be a perpetrator. Some people say, well, that's an objective question. It's part of the objective side of the offense. You could separate that from the subjective side, not have subjective elements there. So there's in doctrine, there's still a lot of thought on that. Not that much in the case law. It's really going very slowly, but it's quite accepted, of course, that we have that. So that is the concept of perpetratorship, and that is separated from the question whether or not a legal person commits or fulfills the other elements of the offense, such as in particular the difficult question, does a legal person have intent or negligence? And there are 2 approaches there. One is to combine intent from natural person and attribute it to the legal person, and the other is to say, well, the legal person itself can have intent or negligence based on business policies, for instance. If you have a shady business that more or less accepts that some stuff is happening, then the business itself is negligent. You don't need to attribute any blame from an individual to the company. So that's the question: does a company fulfill the elements of the offense? But that's not most of it. I think that the most interesting parts are when it comes to the relationships between the natural persons and the legal persons. I think what you see in many jurisdictions is that is a very important question. And what we have in our law is that we have particular modes of participation that are available for natural persons to participate in the crime of a legal person. I wouldn't view the relationship between a legal person and a natural person as being adequately explained by saying that the legal person participates in the act of a natural person. It would be very strange to me. I would say a natural person participates in the crime of a legal person. That is how our criminal law views that. And we have that particular mode of participation called actually leading the offense of a legal person. And it's very much used. So very often that natural persons are prosecuted for actually leading an offense of the legal person. So then the legal person is the perpetrator and the natural person participates in that offense. And there are certain standards. And of course, the benefit is that you don't need to fulfill all the elements of the crime for the natural person to be held liable. You do need intent, both as towards the offense and towards the participation. And you need some kind of control within the natural person, some position of control and acceptance. But that is a very interesting and useful method, because it enables our prosecutors, and then we go to the procedure side, it enables prosecutors to choose. And of course, we have cumulative liability, and that is you can be very creative with that. You can combine both the legal person and the natural person, prosecute them both. We do think that sometimes you will get into nebis idem problems. As Peter Sonker just said, he didn't see that happening. In our jurisdiction, we would see that happening, particularly when we have a very small company with one person, more or less is more or less identical to the company, then we would accept that there can be problems if you prosecute both the company and the natural person. But it comes in handy. For instance, when a natural person is deceased, he can prosecute the legal person. When the legal person is nowhere to be found, has been dissolved, or the money is gone, you can prosecute the natural person for factually leading the offense of the legal person. Sometimes it can be difficult to prove that the natural person, if you want to prosecute a natural person, sometimes it can be difficult to prove that the natural person actually committed all the elements of the offense. Then prosecuting that natural person for actually leading the offense of the legal person can be a very good alternative, because you don't need to prove that that person fulfilled all the elements. So there are choices to be made there by the prosecutors, and sometimes, of course, depends on the money to be found, but also on the sanctions to be imposed. The solution is not thought as being very effective, because you can easily set up a new legal person doing the same stuff. Fines, of course, are primarily interviewed. I would like to think about the possibility of community service by legal persons. I think that could be a creative approach. I think some legal persons could do very good things for society, actually, if you impose them community service. And a very important sanction can be supervision. If a court could appoint a person overseeing the actions or participating within, being active within the legal person in the business, and then reporting back to the court at the end of the suspension period, that can be very effective, I think. But those would be some sanctions that could come into view. So in the end, this story for our jurisdiction is very pragmatic, as you said. Indeed, we don't have a good theory, we just do it and we stumble upon, and the thing is that history shows that we just keep expanding, and we keep expanding liability and getting into new territory, and without much problems. I think it's fairly accepted, it works, and can be effective. So, thank you for your attention.
Thank you very much, Pim, for your presentation. I should say that it's very interesting to hear about actual problems related to prosecuting corporations for crime, and about those problems overcome by prosecutors in the Netherlands. In my country, we do have a quasi-penal system of responsibility of corporations, but no corporation has been prosecuted in recent years. So it's just like a fairy tale for us to hear that there are some corporations actually currently prosecuted in another member state. I am still encouraging the attendees to ask questions. Now we have completed the section of the webinar where panelists take the floor, and so I would like to move on to the Q&A session. And as far as I can see at this point, we have one question that is addressed. This is a question from Professor Andrzej Klip, and it's addressed to Peter Tsonka. Peter, can you hear me? Yes? Okay. I will read the question and then ask Peter to react. The question is asked in relation to what Peter stated on Article 67 of the treaty. The fact that you regard this article as a stand in the way to a directive imposing corporate criminal liability surprises Professor Klip. Article 67 of the treaty, like Article 3 of the Treaty on the EU, are very broad provisions referring to respect for the identity of the member states. whereas Article 83.3 of the Treaty on the Functioning of the EU is very specific for criminal law and could be standard of measurement on this issue. And Professor Kleeb ends his question with, ends his entry with a question to Peter: how do you see this? So if I may ask you, Peter, to react, to elaborate a little bit. Thank you.
Thank you very much. Professor Kleeb always asks the best questions in the audience. It's very difficult to answer his questions. We have never tested Article 67 in reality, so we all have perhaps a different interpretation of what this respect by the union of national legal traditions and legal systems should mean. Our interpretation in the Commission, and certainly in my DG, is that this goes as far as preventing us from unifying, harmonizing beyond minimum harmonization certain systems of sanctions, including, for example, the sanctions that would apply to legal persons. So we may be wrong. This was never interpreted, as far as I know, by the Court of Justice. And we would not like to run into such interpretation anytime soon. But if we build up sufficient political support for introducing a harmonized corporate criminal liability regime in the European Union, and all of our member states, including the ones that do not have such a system now, agree that this would not offend in any way their legal traditions or legal systems, perhaps we will get there. So it was to some extent speculative from me that this is how we would see the problem unfold in the future. At least at this stage, as far as our revised directive on environmental crime and the provisions included in that new draft on the liability of legal persons is concerned, we will not attempt to make such a harmonized criminal regime for corporations. We will keep the system that we have since the PIF protocol, and that is to offer the same flexibility that we have under the current directives and the pre-Lisbon instruments. And for the very same reason that many of you have actually supported, which is it's not the name which matters, it's the efficiency of the system. Because whatever system our member states introduce in reaction to a union directive, when they implement and transpose such a directive, the requirement is still that these sanctions need to be effective, proportionate, and dissuasive. So it's one thing that some of us believe in the stigma that is brought by criminal sanctions, but it might be that in terms of efficiency, certainly financial efficiency, non-criminal sanctions may be as efficient as criminal sanctions. So we will remain with the current system for now and see whether in the future we manage to bring sufficient political support behind a more standardized regime for criminal liability of legal persons. But as I said, honestly, as far as the 67 is there, I don't believe that it will happen. But maybe I'm wrong. So I'm open to be convinced. Thank you.
Thank you very much, Peter, for this reaction. I don't know if Professor Kleeb would like to ask another question or react to your reaction. I would like just quickly say that I think that at this point of the development of the EU criminal law, we should maybe try to enforce the provisions that we actually have in the law, and this magic formula of effective, proportionate, and dissuasive, that's the formula that has not been enforced by all of the member states, mine included. And I think that maybe we should just try to reach this milestone and maybe then go further on with the criminal liability. So I fully agree with your approach here, Peter. So thank you. We have another question from Alfredo Rizzo, who is asking, on criminal law, the EU approach is that of aiming at a good level of harmonization without interfering with national traditions. That's why the penalties are generically defined at EU level as adequate, proportionate, and dissuasive. Is that enough? I'm not sure if I understand the question correctly, but I think that we have just tackled this issue of adequate, proportionate, and dissuasive sanctions. And yes, on the EU level, that's the formula that has been used by the European legislator, and I think we all agree in this panel that we should make sure that the sanctions are indeed effective. We are actually running out of time for other questions. I will just see maybe some no other questions. I was just wondering. I was just wondering about one issue regarding to the attribution of liability, and I'm not sure if we have enough time to address this issue, but I'm just throwing it in the open. Do we really, and the question that bothers me is, do we really need to have an individual to attribute liability for corporations? As far as I know, in some member states, there is no need to actually identify the individual when a decision has been made by a corporation, by an organ within the corporation, but no actual member of the organ of the corporation can be identified. Then there's the question whether we need to have this identification or not. I don't know if anyone would like to react to this. Any panelists? Maybe Pam, would you like to? Because this was something that you have been talking about a little bit.
Yes, I think I can shortly comment on that. In our system, indeed, it is not necessary to identify an individual for attributing an act to a legal person. You can, of course, and the case becomes a bit stronger if you have a particular individual, for instance, when he's high up the ladder in the corporation. We dropped that organ theory. We used to have that back in the past. The requirement that an individual is, or that the decision is taken by an organ of the corporation. We don't have that anymore. So now you can look at the whole of all of the circumstances, what happened, who was involved, at which level. Particularly with more complicated corporations, that becomes, of course, a bit of a difficult task. But you can take a look at the whole, and then courts need to explain how they decide on that. So that's important as well. You need to lay that down in the verdict. What do you find? What do you see? What do you see happening? So it's a bit proceduralized, actually. There are some circumstances that you can use. Was an act for the benefit or for the use of the corporation? Was an employee involved? Was it done in normal business operations? And did the legal person control the act and accepted that it happened, or didn't do enough reasonable care? So there are some usual things that you can use in building that decision, but you need to explain those building blocks to get there. So it really, well, matters how you do that.
Thank you for this. I think this is very interesting. Mark, did you want to say something?
Yes, maybe two things to add that we might maybe distinguish between that we have to establish that a natural person was acting within the corporation. And then maybe we can leave it open who it was as the concrete person was that. Because if we cut this link completely to natural persons, then you would more or less cut the link to the offenses that have already been established under criminal law. And I think one main advantage referring to the established criminal law offenses is that we already have thought about what kind of behavior should be criminalized, how far going should this go. And if you say we have developed a corporate separate system, and then you would start maybe from the scratch more or less, then you would have to think what kind of effects can be attributed to a corporation. And I think this has already more or less been done. And with a kind of natural person, you can link the idea of a kind of criminal responsible behavior to the corporation. And so far, there's lots of evidential problems where you maybe can say we do not have to establish who it was from the corporation, but I would say we have to establish that someone at least was it from the corporation and not some third person for whom the corporation is not responsible at all.
Thank you for this contribution. That's indeed something that we will have to think about when and if we implement the project. And I will just ask Fabio. Fabio, would you like to say something, like a few words at the end?
Yes, Elena, thank you. Yeah, of course, first of all, I would like to thank all the panelists for their participation. It's been extremely useful for us, I think, to have your contribution in elaborating our project. And then, yes, I agree with most of the things that have been said. I would like to thank Mark for his remarks on cooperation. Yes, it's needed to have a balance when it comes to cooperating. Otherwise, the cooperation becomes something like an extortion, might become something like an extortion, and we do not want this, of course. I think that the most recurrent issue in our debate, it's the link between the corporation and the individual. I mean, when we speak about corporate responsibility in modern criminal law, we do have to think that there is also an individual, and the link between individual and corporation, it is crucial for the effectiveness of the system of responsibility. We were speaking just now about the issue of the individuation of the material author of the crime or of the illicit act. Yeah, I agree with Mark's concerns about the need to be sure that at least, even when it is not identified, it is someone who actually is within the corporation. But I have to say that maybe sometimes this might not be enough also. No? For example, in Italy, we also do not have the need for the identification of the perpetrator, and thus the society, the legal person, might be prosecuted even if the author of the crime is not identified. But if we know that is someone within the corporation, we still do not know if, might not know if he or she is in the executive board or if she is under control of other person. And this is extremely relevant in our system, because from the position of the perpetrators actually depends the criteria of attribution of liability for the entity. So I fully understand the need to maintain the liability of the legal person, even when the specific individual is not identified. That this is actually one of the the main goal of the corporate liability, you know, held someone liable even when you do not identify the specific person. But on the other hand, yeah, we should also consider that effective defense requires to know which is the fact that you are accused for what you are accusing me. And so yeah, even in this issue, we should find, I think, a fair balance between efficiency, deterrence, and rights from the other side. But I think today's discussion really much helped us to individuate the most sensitive issues.
Yes, thank you, Fabio, and I fully agree that the discussion shows us the difficulties that lie ahead us when it comes to the project and the research. And I'm not even mentioning the result of the project, that is the model rules, when we will have to formulate the model rules. It's going to be really hard and difficult. But just to close up, I can see Peter just smiling with sympathy and I hope not pity to us. Just one, okay, thank you. Just one closing remark. I would like to thank all panelists for their participation and the attendees for the questions. I just want to say that I am happy to hear that all the panelists were shared our vision of a more comprehensive approach when it comes to the project, and adopting those 3 pillars for the project, that is the attribution of liability, sanctions, and procedural issues. We are again, with those 3 pillars, we are somehow maintaining the tradition of the EU criminal law developments, and that's to stay within this tradition idea and agenda. So thank you very much, and I am very much looking forward to working with you on the project. Thank you to ELI for organizing the webinar that concludes the annual conference of the European Law Institute. Thank you again, panelists, and stay safe and stay away from the virus all the time. Thank you very much. Thanks.